Red light. There we are. We are live. Good morning. Good morning. Welcome. Good day. Good afternoon. Just depends on when you are watching this particular broadcast. I just want to welcome you to Lyonsview Financial Fridays. My name is Clara Lyons-DeVaughn. I am the broker owner of Lyonsview Realty, and we provide residential, commercial for small businesses and nonprofits, and property management services. As you also know, we've launched Lyonsview Academy, and we'll be providing residential licensing and continuing education, also credit counseling and distressed homeowner solutions, and lifestyle, health, wealth, and wellness education. So shout out to those people who are on our quarantine food challenge. We're having a great time doing meatless meals. It's been pretty fun. As you know, Lyonsview Realty, we launched our Financial Fridays really to help you stay current on trends that impact your bottom line. Our goal is really to provide you with resources, that information, tips, anything that we can do to assist you in making the best financial decisions. And our commitment is really to maximize your wealth building power now and in the future. So glad that you tuned in today. Welcome, welcome, welcome. Feel free to like and share this video. And as you know, our guests are here as a resource to you. So if you have any questions, just post them in the comment section and we'll try to get to those. If not during the show, we'll swing back around and answer the question after. Today, we have a very, very, very special guest, Mr. Russ Nesevich. Did I say that?
Well done.
Okay, Nesevich. And, I just believe in divine intervention. I was looking for something, for someone who was adept at estate planning, which is a passionate area for me. As you know, I lost my husband unexpectedly and, was really not prepared for all of the things that I needed to have in place, or we needed to have in place as a family. And also being in the real estate industry, I always see people who are in circumstances related to their property, and we have to go to court. We have to do all these things because they didn't have the proper documents in place. So this is a very timely subject. You can check out of here anytime. You can become incapacitated anytime. But especially as we're going through this pandemic, we're having much more people make their transition, many more people who are incapacitated during the season as well. And I just wanted to share a little bit about Russ. He really ensures that his clients have optimally planned to protect their families and their assets through all stages of life. He's established lifetime plans to ensure that children are protected and provided for should anything happen to their parents. He also helps his clients preserve wealth, minimize estate taxes, and pass their values on to future generations. So it's really in line with Financial Fridays. So he helps families navigate complex law of estate planning and identify solutions that best meet their needs. He's an award-winning, engaging speaker. He has done business succession planning and other related legal needs, And you spent 13 years as a Resource Securities, a firm that creates alternative investment products focusing on real estate and credit markets. So Russ is a wealth of information, and today we're going to focus on estate planning specifically. But welcome, Russ.
Thanks. Thank you for having me.
Yes. So if you could, anything else that you want to share about yourself?
Now, so I'm an estate planning attorney. I spend 99% of my time focusing on estate planning. I have a law practice in Morristown, New Jersey, and an office in Manalapan, New Jersey as well. So we have a location in Monmouth County and in Burlington County. I have a wife, happily married for, I think, 17 years now, 3 kids. And it's everything that you said. So we do estate plans for people to make sure that if something happens to them, if there's an emergency, if someone's incapacitated, or if someone passes away, that they're protected, their families are protected, and they've set everything up in the way that they want to. And that's what we focus on here.
Indeed. Why did you focus on this area of law? I'm really curious about that.
That's a terrific question. So when I was right out of, let's see, I was probably about 13 years ago. So I was in my early 30s, and I was actually in law school. I went to law school later in life. I went part-time at night and got my JD and my MBA at Rutgers here in Camden. So I did the JD MBA program there. And I had just started law school. I was in my second or third year. And my father passed away, and he had cancer. We knew he was going to pass. It was a sort of a long and horrible process and situation. And my mom went to an estate planning attorney who did all this stuff. He created this trust, and he started moving assets around, and he started doing all these things. And I was in law school, and I couldn't understand any of it. So the complexity of what he was doing and why he was doing it and his inability to explain it really, really frustrated me and frustrated my family. Yeah. And it was something that I took a huge interest in. So when I graduated law school, I had a background in financial services and wealth management. I have my securities licenses. So estate planning and investments, really, there's so much overlap. So it just was, not only was it the perfect fit from a knowledge and expertise background, but it was also the perfect fit in terms of something that I had dealt with and my family had dealt with that I didn't want to see people deal with. One of the best compliments that I get from my clients is when we're done with the work, they say that they understood it, that it was easy, it was simple, and they know what they're walking out with. So the simpler I can make it, the easier I can make it, the better I feel. That's sort of our goal.
Yeah. And I want to say, just from what I've seen of your work, you do an excellent job of making it simple, easy, and concise. I love, love, love that.
Thank you.
About you. So we'll start with the basics. What is an estate and what exactly is estate planning?
Sure. So, a lot of people think estate planning is for the wealthy, and it's really not. I mean, it is for the wealthy, but it's for everyone. Estate planning is ensuring that you transfer your assets in the way that you want, when you want, and to whom you want. It's about protecting your family from fighting, from disagreements, from somebody coming in and claiming to be in charge when they're not the person you would have wanted in charge. It is making things as easy as possible for not only your heirs if you're gone, but if you're incapacitated, for the people who have to manage your affairs, whether it's your financial affairs or your healthcare affairs. Mm-hmm. So estate planning is about all of those things. It's about your stuff. It's about when you're gone. It's about while you're alive. It's about making things easy and efficient for yourself and for everybody else. It's really a gift to your family and to those around you. So that in a nutshell is what estate planning is. It's just having a plan for your life and for your passing.
Indeed. A lot of people think, oh, I'm too young. I'm only 18. I don't have anything, you know. So even like what types of things go into an estate besides property? Because people think property when they think estate.
Yeah. So I'll answer that question, but I want to sort of make another point to something that you just brought up about people being young. One of the most important times that we deal with people and we wind up doing their estate plans is when they have kids. Mm. Because one of the things that we do that's really important is we allow people in their wills to name a guardian and to create trust for the children. The last thing that you want, if you're a young person, you have children, something happens to you, life insurance pays out, you have a little bit of money, is for that money to sit until that child turns 18 and then for them to get a really big check. So being young is not an excuse to not have an estate plan. Quite the opposite. When you're young, you have children, you're starting a family, probably the most important time to have an estate plan. Because if something happens to you and your spouse, you want to ensure that your kids are taken care of in the way that you want, by whom you want, right, and that their assets are taken care of in the way that you want, by whom you want. So really, really important. To answer the question that you asked, there's really 5 main documents that every single adult should have. It starts with the will, though I would argue that the will might be the least important document because the will is for when you're gone. So if you don't have a will or you've done a poor job with your will and it all gets screwed up, at least you're gone and you're not the one having to deal with it. So but the will is talks about what happens when you're gone, who's in charge, where your assets are going to go, all of those. The other 4 documents are really for while you're alive, which I think makes them all the more important. It's about who's going to manage your affairs, who's going to deal with your stuff, with you in the event that you can no longer manage your own affairs. So those 4 documents are the power of attorney, which names someone to be able to deal with your financial affairs if you can't deal with them yourself. And then there's 3 healthcare documents. There's healthcare power of attorney, which nominates someone who's going to make healthcare decisions for you. There's your HIPAA release, which gives them access to your medical information. And then there's your living will. And the living will really deals with end of life decisions. It's those decisions if you're terminal, if you're vegetative. Do you want forced hydration? Do you want forced nutrition? Do you want to be on a ventilator? If it's only there for the sake of keeping you alive, and doctors have decided that there's really no chance of recovery. So the living will becomes very important because you get to make your wishes clear in terms of what you want for those end of life decisions. Most people, they don't want forced hydration, they don't want forced nutrition unless there's actually a chance that they'll recover.
Gotcha. And in terms of the stuff we're talking about, it could be your vehicle, it could be your bank account, it could be your retirement account, it could be your furniture, it could be real estate, it could be your life insurance or your insurance policies, those types of things. So kind of what makes those documents active? Like if you were to put them in place, when do they activate? Like how does that work?
Yeah, great question. So when you sign them, they're active. So there's very specific ways in New Jersey and in all states the documents need to be signed. So for example, the living will, the healthcare power of attorney, the power of attorney, the HIPAA release, all need to be signed and notarized. They need to be signed in front of a notary. Once you sign them and they're notarized, they're valid. A will, they're sort of steps, and I don't want to get too technical, but you can just sign a will, but that makes it far harder to probate. Right? They need to be signed in front of a notary. Once you sign them and they're notarized, they're valid. A will, they're sort of steps, and I don't want to get too technical, but you can just sign a will, but that makes it far harder to probate. Right? They need to be signed in front of a notary. Once you sign them and they're notarized, they're valid. A will, they're sort of steps, and I don't want to get too technical, but you can just sign a will, but that makes it far harder to probate. Right? Beneficiary designations match up with the trusts that you may have created in your estate plan. Because if they don't, so you may have created a trust in your will, but if the life insurance policy doesn't name the trust as the beneficiary and instead names an individual, that money is never getting into the trust, it's going outright to the individual. So it's really important that you coordinate things like life insurance and retirement assets with your estate plan.
Gotcha. So actually, there's a separation. So with the on the trust side, they're beneficiaries of policies like life insurance, and then for other assets, there's it goes directly to a person or whoever you designate.
It can, but it really depends on it's all a puzzle of making sure that what you do on the estate planning side and what you're doing on your financial side all fits together and works the way that you want it to work.
Gotcha. We had someone come and talk about life insurance policies and the importance of having named beneficiaries. So the piece that you're adding to that is that if you also have a trust, just make sure that the two match up.
Yes, that's exactly right.
Okay, got it. So when people put the plan together, like they have all of these documents, where should those documents be kept?
Great question. So a lot of people will keep their documents in a safe deposit box. The problem with doing that is if you're sick or you pass away, you need the documents in the safe deposit box to get into the safe deposit box. So do not keep them in a safe deposit box, or you can keep originals in a safe deposit box or copies in a safe deposit box, but then make sure that you also have a set of originals or copies that are easier to access. So normally we advise our clients, keep them in your home, keep them on a bookcase, make sure that your executors, your powers of attorney know that you have created these documents, your executors and your agents. Make sure that they know where they are. They're in the office on the third bookcase over in a blue binder, so that they can get them as needed. The other thing is, if you trust your executors, which hopefully you do, if you trust your agents that you've named in your power of attorney and your healthcare directives, it probably makes sense for them to have a copy. Because if something happens to you, the last thing you want is for them scrambling to figure out where the documents are. You want them to know that they have documents that puts them in charge of your affairs if something happens to you.
Mm-hmm. And how do you know that those are the most recent documents? Is there a way on the document to designate that, or?
Yeah, so good question. So any document that you create will say that you rescind all prior versions of the document. And any document that you create is also dated. So you raise a very, very good point. So if you're creating new documents, you want to do a couple of things. You either want to destroy old documents. You never want two wills floating around, even if they have two different dates on them. You want to either destroy old documents, or if you named an agent to serve as your power of attorney 5 years ago, and you gave them a copy, but that person is no longer the appropriate person and you've created a new one, you want to send them a letter and rescind that power of attorney. So it's an excellent question that you ask, and it's something that you want to be thoughtful about.
Mm-hmm. So when you're talking about naming an agent, let's talk a little bit more about that.
Sure.
So I prepared these documents. Let's say I've named my mom as my agent. So who can actually be your agent? Is there a criteria for that? Does it have to be a family member? Does it? Yeah.
It's a great question. Anyone can be your agent. The bigger question is who should be your agent. So you always want someone you trust. So in my opinion, the power of attorney is probably the most important document we create and the most powerful document we create, because the power of attorney gives someone other than you the authority to act on your financial affairs while you're alive. Now, there's two different ways to do a power of attorney. One is immediate, which means the second you sign it, if you named your mom can go and raid your bank account. So if your mom develops a drinking problem or a gambling problem or a drug problem, or just decides that she needs some cash this month, she can use that power of attorney to access your account. So that's an immediate power of attorney. The other way to do it is what's called a springing power of attorney, where in order for your mom to be able to use it and to access your accounts, the power of attorney actually says that she needs to be able to demonstrate that you are actually incapacitated. And she can do that with a letter from two doctors. She could do it with a court order. A court order is kind of a hassle, but a letter from two doctors, if you're actually incapacitated, should be something that's pretty easy to get. So normally we do what are called springing power of attorneys, so that there's that layer of protection. And we name someone who you trust with your life, for lack of a better way to say it, but certainly with your money and with your financial affairs. It can be your mom, it can be a friend, it can be a sibling, it can be your financial advisor, your attorney. You just want it to be somebody that you really trust to act in your best interests in the event that something happens to you and they need to use that document.
Gotcha. So your attorney or should have a copy of your documents as well as whatever is in the safe deposit box, or is there like one official document?
Yeah, so you always want to have a set of originals. That's your official document. But generally, your agents or your executors, you may want them to have copies. And generally, it's a good idea for your attorney to keep a copy of the documents, whether digitally or physically, because in the event that someone can't find your documents, but they know that at some point in your life you went to Nesevich Law and you had your documents done, they can always call up and we can get them for them. And documents get lost. If God forbid there's a fire, we can always retrieve copies of documents that we have.
Right. An original document would have The raised seal of the notary, basically. That's how you.
Yeah, so that's exactly right. Now, interestingly, in New Jersey, you don't necessarily need a raised seal anymore. So all you need is the stamp, or for them to sign. And the other thing that I'll share with you that a lot of people don't know is in New Jersey, actually, any attorney can act as a notary. So I happen to be a notary, so I'm able to notarize my clients' documents. But even before I became a notary, as an attorney, any attorney can sign off in the as a notary and swear that that was in fact the person who signed the document. So you don't necessarily need a raised stamp anymore. You just need a notary or an attorney acting as a notary. And it's always best to have originals when you're trying to do things. So sometimes you go to a bank and they fight back and they don't want to take a copy for whatever reason. Originals are always best.
Indeed, indeed. So when should you change? There were 5 documents that you mentioned. When is the best time to update or change? Like what would trigger changing those documents?
Yeah. So a good rule of thumb is that every 2 to 3 years, you want to at least review your documents. So has anything changed? Have you had a change in your relationship with the executor? Has your child, who was 16 at the time that you created the documents, they're now 19 and they are intelligent and thoughtful and respectful and a mature adult? And they are now the person who should be your executor or your agent, rather than the person that you named back when your child was not yet of legal age. So every 2 or 3 years, you should review your documents no matter what. You should certainly review your documents anytime you've had a major change in circumstances. So if you win the lottery and we didn't do tax planning when we put your documents together, you might want to review your estate planning documents. If you get divorced, if a spouse passes away, if you have another child, if a child passes away, if there's been a change in circumstances with the relationship of someone that you named to have some authority, all of these are reasons that you want to review and possibly change your plan.
Gotcha. And with the I guess distribution, I'm going back to the wills. So if you are in say a blended family and you have or you're putting a will together, what are some of the types of things that you might want to consider?
Yeah, great question. So blended families are sort of the ones that we see where there's the most complexity in the estate plan for all the obvious reasons. So a husband and wife come into a marriage together. They both have kids from a prior marriage, potentially, or one of them does. And they want to ensure that if something happens to them, those kids are taken care of, but they also want to ensure that their spouse is taken care of. So I'll sort of give you the nightmare scenario. The nightmare scenario is that you don't have a plan. You get married. Over time, you put everything in joint name with your new spouse. So you buy a house together, that's in joint name. You have a checking account together, that's in joint name. They're the beneficiary on your life insurance policy. They're the beneficiary on your IRA. You pass away, that spouse, because of the way deeds are titled, you know more about real estate than I do, because of the way deeds are titled, because of the way the beneficiaries are, because of the way that the checking accounts are joint, everything goes to that surviving spouse. That surviving spouse is under no obligation whatsoever in their will to take care of your children from your first marriage. So blended families is when it becomes really important, because you might want to say that upon your passing, you're going to leave a trust for the surviving spouse that they can access over the course of their lifetimes. But anything that's and they can only access a certain amount every year. But when they're gone, that money's going to get to your kids. Or you may want to do some planning that says, upon my passing, my spouse doesn't need it all. They're going to get the house and they're going to get the IRA, but I'm going to have a life insurance policy for my children. So there's all sorts of things that you can do to ensure that scenario where spouse number 2 or spouse number 3 doesn't get everything and nothing gets to your children who you may have wanted to take care of. So
Yeah.
blended families, estate planning becomes all the more important.
And if you're incapacitated and you're in a blended family, who has the legal right to say what happens and what doesn't happen?
Yeah, well, isn't that a great question, right? So imagine that you have adult children and you're in a blended family and you're incapacitated, and your husband and your adult child show up together and they have different opinions on what the course of treatment should be, or whether you should stay in your home or go to a long-term care facility, or anything else for that matter. How your money should be spent. Are we going to use it to upgrade the house so that there's wheelchair ramps and 24-hour care, or are we going to use it to put you into a facility? And your adult son who's 35 years old and your new husband who's 60 years old disagree. Who's in charge? Well, isn't that a great question? So who's in charge? The last thing you want is for the two of them to be in front of a judge and have a judge decide who's in charge and who the guardian is going to be, especially in the event that they don't get along and have completely different ideas on the path, which is why documents like healthcare powers of attorney to name an agent and durable powers of attorney to name a financial agent are so important, because we want to avoid, one, the two of them fighting at your bedside, two, the two of them fighting over money and assets, three, the two of them fighting over course of care, and four, a guardianship proceeding at the local courthouse. So if you have those documents, you get to decide who's in charge. Is it your husband, your adult child? Who's going to make those decisions? Maybe one of them will be the financial power of attorney and one of them will be the healthcare power of attorney. It's completely up to you, but we'd always rather you make those decisions while you can and you're capable than have to have them decide or have a judge decide who's going to make those decisions.
Yeah. And if we were to flip the script, let's say it's the child who's an adult child, but they're not married and they're, 25, but the parents have moved on. They have, there's a mom and dad here, and there's a dad and mom over here.
Yeah. Who's in charge?
Who's in charge? Yeah.
Right. And which is why it's even important for a 25-year-old to have those documents in place. In fact, we normally suggest that when you're 18 and you go off to college, you at a minimum get your healthcare documents in order, because you may not have any assets and you may not have any stuff. So we're not too worried about somebody accessing your checking account, because you're probably putting the money in that checking account anyway while they're at school. And we're not too worried about their will. But if your child is 18 or 19 or 20 and something happens at college and they're laid up in a hospital bed and you call the local hospital because you haven't heard from them in a couple of days, they can't even give you health status because they're a legal adult. They can't share their protected private healthcare information with you unless there's a HIPAA release, unless there's a healthcare power of attorney. So one of the things that we do quite a bit is when kids go off to college, their parents will reach out to us and say, hey, I need to get all the documents in place for my son or daughter so that if something happens to them, I can access their medical information. I can make medical decisions for them. Incredibly important.
Yeah, that's a really, really valid point that I think people overlook a lot and, think that they have authority because they're the parent. Well, once that child becomes an adult,
Yep.
they have full rights of adult.
They are an adult.
Yeah.
They're an adult.
So having that power of attorney or the healthcare power of attorney is very important in the event that your young person, your adult young person becomes incapacitated.
Right, not so young.
Yes, not so young. So let's talk a little bit, change stuff about trust. So what is a trust and kind of what are the different types?
Great question. So we can really get into the weeds on trust, and we can go for like another 3 hours talking about trust. I don't think you want that. So we're going to keep it very, very simple, and I'll say a few things. There's really two kinds of trusts. There's a trust that you can create during your lifetime, where we can create a trust now and put money into it, put stuff into it, put your home into it. So that's trust number one.
Okay.
And then there's a trust that exists after you're gone for the protection of your assets for your family.
Okay.
In New Jersey, most people, not all, most people don't need a trust today. So one of the reasons that most people use trust during their lifetime is to avoid probate. Probate is the process that happens when someone passes away. You go to the local courthouse, someone is named an executor, and the assets have to pass. New Jersey is one of the 50 states in the country that has probably one of the 3 or 4 easiest probate processes. So the idea of having a trust and having that extra layer of work today while you're alive, only to avoid what is a pretty simple and inexpensive probate process, not a great reason to do it. Now, there's other reasons to have trusts, whether it's Medicaid planning, special needs. There's all sorts of reasons to have trusts that make sense. Simply avoiding probate isn't one of them. Having the trust when you're gone for the people that you leave behind, so that when you leave them assets, those assets are protected for that person from things like divorce or bankruptcy or creditors or those types of things, that to me makes a heck of a lot more sense. So quite often when we're doing planning for people, we'll occasionally do trusts now if there's a really good reason to do it, but quite often we're doing that trust once the person passes away for the benefit of their kids. We're always doing trusts for the benefit of the kids when someone has minor children. So if you have children who are under the age of 18, they can't inherit assets outright. They get really big checks when they turn 18 years old, and that never ends well. You want them to inherit that money in a trust with an adult in charge, doling out the money, making decisions, and then giving it to them over the course of their life per your decision. You may decide that they should get the money when they're 25. You may decide they should get the money when they're 50 and get a little bit at a time along the way. So there's lots of reasons to use trusts. Some of them make a lot of sense. Some of them don't make a lot of sense. It really depends on your specific situation.
So in the event that they don't do any of the things that we've shared today, they don't get any of the 5 documents,
Yeah.
they have a trust, or maybe they don't need a trust, but let's say they end up in probate. Now who's in charge of deciding what happens, and if they're like multiple children, if there's no spouse, no children, no heirs, like what happens to a person's estate when
So I hate scaring people. So sometimes it works out just fine, but occasionally it doesn't work out so just fine. So being in probate or having to have your estate go through probate, not that big a deal. The concern is when you don't have a will and you haven't named an executor, so you haven't named who's in charge, and you have 3 kids, and maybe those 3 kids don't get along. And now you've passed away, you don't have a will, your estate has to be probated whether you have a will or not. And instead of an executor who you would have named in your will, the county, the surrogates court appoints what's called an administrator. It's basically the same thing as an executor, but it's an administrator. That administrator is appointed based on who steps forward. So you've got 3 kids and they all raise their hand and they say, I'll be the administrator and I'll be the administrator. And then the court has to decide who's going to be the administrator, and they don't get along. So all of a sudden, one of them's named the administrator. The other 2 are arguing over the administrator. Legal costs are racking up. The administrator, unlike an executor, has to post a bond when you're doing probate. So they've got to come out of pocket for basically an insurance policy that they're not going to screw anything up. Bad things happen. So bad things happen when you haven't decided how your assets are going to go, who's going to be in charge. Now, sometimes it ends just fine. You have 3 kids and they get along wonderfully, and the 3 of them get together and they say, look, you be the administrator, we'll all work together and everything will get done. And isn't that great when everything is all sunshine and daisies, right? Unfortunately, what we find is that it doesn't always wind up going that way. Even more importantly to me isn't the will, it's the documents for during your life. It's the healthcare power of attorney, the durable power of attorney. And I love the question that you keep asking. I'm going to steal it. Who's in charge, right? So if you're incapacitated, you probably have a pretty good idea of who you want in charge. Let's name that person. And even more importantly, you might have a really good idea of who you don't want in charge. So let's make sure that we name someone to be in charge, so the person you don't want in charge doesn't wind up in charge.
Awesome. I have a couple of scenarios that people had, so we'll run through these quickly.
Sure.
A mother dies in childbirth. What happens to her child now and in the future?
Good question.
Or what is she?
Hopefully, there's a father in the picture, right? And the father would have parental rights. He'd have custody. So depending on if the mother and the father own a home.
Okay, so it looks like we are having some technical difficulties. Good morning. I'm going to see if I can fix the problem right quick so we can continue. This is a do it like that. This is a replay that I thought was very timely, given that we've had a year where so many people have gone through transition. You know, it's been a very difficult and challenging year where folks have gone through transition, and this information was very timely. So I wanted to present it again. But I'm having difficulty with my system. So give it 2 more seconds here, and if we can get it to come back, great. If not, I just want to encourage everyone to make sure that you have your 5 documents in place, and you can always go to YouTube, Lyonsview Realty Financial Fridays, and see this video in its entirety. It's Lyonsview Realty Financial Fridays, and it is the estate planning segment. So I guess okay, I think we're good. Give me 2 seconds here. And see if I can bring it back. But it's on YouTube, the Financial Fridays segment on estate planning. So you can replay and watch this video at any time. But I'm going to see if I can get us back here so you can see, get the rest of this information, because this is a really great segment on estate planning and the things that you need to know. So let's see if I can get us back. Okay, nope, don't want that. Okay, share screen here. Let's see here. I don't know if you can hear me. Okay, I think we're good to go here. So I think we are good. All right, I think we're good. So I'll do it like this. This is not coming out like I expected. Sometimes you have technical difficulties and you think you have them all worked out, and you don't. So I'm going to try this one more time. I just want to get to where we were before. Okay, I think we're good. So we've got sound. Yes. Yes. Okay.
There's a father in the picture, right? And the father would have parental rights. He'd have custody. So depending on if the mother and the father own a home jointly, by way of the deed, the father now owns the home. Beneficiaries on life insurance, 401k, the father now owns the home, right? And the father just, boy, what a horrible situation. The father just became a single dad, but the father always had parental rights, right?
Yes.
Should something happen to the father, or should dad not be in the picture? Well, now you've got a child without a parent. We want to make sure that mom has, in her will, said, if I have children, here's who I want as the guardian of the children. And if I have assets, here's what I want happening to those assets for the benefit of that child. And that's whether mom dies in childbirth or, I mean, look, God forbid, we all go out with our spouse on a date on a Friday night. And sometimes people don't make it home. It's a horrible, horrible scenario. But those kids who are home with the babysitter, what happens to those kids? Well, we want to know that those kids are going to be raised by my sister and not my wife's sister, or my wife's sister and not my sister, right? We know who we want raising those children. The best way to make sure it happens the way that you want it to happen is to have your affairs in order.
Indeed. Got to know who's in charge. Another scenario, a senior goes into a state of dementia or Alzheimer's.
Yeah.
What has to be done to manage their care, sell their home, manage their assets?
So there's the easy way and the hard way.
Okay.
The hard way is a guardianship proceeding through the court. 3 to 6 months, probably $3,000 to $5,000 in legal fees, potentially multiple people stepping forward and saying, I want to be the guardian. And then the court has to figure it out. And once the guardian is named, they basically lose their legal rights. There's a guardian of the person, there's a guardian of their financials, and those people are in charge of those two things. If you want to avoid a guardianship proceeding, healthcare power of attorney, durable power of attorney. You name those agents, you name who's in charge. Someone has dementia, someone has Alzheimer's, we're set. And look, you know this just as well as I do. We see those things more and more often. Yes. And it's not because Alzheimer's and dementia have suddenly come out of nowhere. It's because our lifespan has gone from, we all used to die after we retired in our early 60s, and now we're living into our late 70s and 80s and 90s. So we're dealing with more of these things. As we deal with them more and more, we want to name people who are going to be responsible for our care.
Indeed, indeed. We kind of touched on this, but let's see. Divorce separation situation. Guardian parent dies unexpectedly, but has indicated money be left to a minor child now in the guardianship of the other parent. Can that parent squander or use those funds for the care of the child before the child becomes 18?
Yeah, so theoretically they could, because they're now the parent and they're now in charge of the money. One of the things that we often do, and I don't know if we do, so you hope certainly that if mom passes away or dad passes away, but it's both their child, that they're still going to take care of their child. What is more concerning usually is when mom and dad are both gone, and you've got a child who's in the care of a guardian, and you have money for that child that is also in the care of that guardian. So one of the things that we always encourage people to do is to name a guardian for the child who's going to raise the child if something happens to you, and a trustee for the money for the trust that's going to be created for that child, and that they be two different people. So there's a system of checks and balances. Gotcha. So that the guardian can go to the trustee and say, hey, the family's taking a trip to Disney this year. I need $20,000 to, out of the trust to take the family to Disney. And the trustee can go, well, wait. You're going on a $20,000 trip to Disney, but little Johnny's share is only $4,000. So we're not paying for your whole family to go to Disney, but here's $4,000 out of the trust for you to take little Johnny to Disney, right? So you always want those checks and balances if possible, which is why sometimes we encourage that the guardian and the trustee be two separate people.
Awesome. A senior puts their favorite child, grandchild on the deed because they want them to get their house.
Yeah.
Will this ensure they get it? What are some of the possible problems, issues that come from doing this?
Yeah, so it's an excellent question. Something we see all the time. So it may ensure that they get it, but it may also come with some unforeseen problems. So for example, putting somebody else's name on the deed, you just gave them ownership rights. So you own the house and they own the house. Well, what happens if they get sued? What happens if they get divorced? What happens if they are in a car accident? What happens if they have to declare bankruptcy? Well, their name is on the deed to your house. So we always discourage that. Don't put anybody on your deed. Don't put anybody on your checking account. Don't do any of those things. All of the things that you are trying to accomplish by doing that can be accomplished through your will, your power of attorney, all the right ways to do it that don't expose you to their liability versus the wrong ways to do it that could expose you to their liability.
Gotcha. So they need to come and see you.
Yeah, look, I mean, at least talk to an attorney about the right way to do it and the wrong way to do it.
Indeed. Let's see. A couple puts their house on the market for sale and there is a charge, the New Jersey estate tax. What is it and when does it apply?
Yeah, so you may be talking about there's something that people complain about a lot called the exit tax, right? So when you sell your house and you're leaving the state, that isn't so much an estate planning issue as that is a real estate issue. Okay. New Jersey actually does not have a state estate tax. So we all complain about New Jersey being a horrible place to live when it comes to property taxes and income taxes. I don't mean to be flip about it or try to be funny. New Jersey is actually a wonderful place to die because we don't have an estate tax. So anything that you leave to children, to grandchildren, you could leave billions and trillions of dollars to your heirs here in the state of New Jersey, and there is no estate tax due whatsoever. So there's not a lot of tax planning that needs to be done for New Jersey estates anymore.
Okay. And I think some of these other things we've addressed. So,
Great.
well, there was a question about contesting. So,
Okay.
what are the top reasons that people contest the person put in charge?
Yeah.
Or the outcome of the wishes of a will or a trust? And is there a formal process to contest something?
There is. So the main reasons people contest is they believe that the person, when they wrote the will, was under some sort of undue influence. So, for example, you have 3 children, and one child is in California, and one child is in Florida, and the third child is here in New Jersey, and the third child lives with the mom, and the mom is starting to show signs of frailty or dementia or Alzheimer's. And the child who is here in New Jersey happens to be in the mom's ear quite a bit, and happens to be the one who's taking mom to the doctor all the time. Now, look, mom may very reasonably decide that they want to leave that child a little more assets because that child has taken care of them later in life.
Right.
There's also occasionally situations where that child will say to mom, hey, you know what? I'm not taking you to the doctor anymore unless you leave me more of your assets, right? So what a horrible thing. So typically when you have someone leaving things unequally to their children, you want to be very, very clear as to why. You want to spell that out. You want to be extra certain that that person who's creating that will has the capacity to make those decisions. You want to make sure that the witnesses know that person. You want to put every single thing in place possible to ensure that that child in California and that child in Florida doesn't come back and say, hey, wait a minute, she really twisted mom's arm on this. He or she, mom didn't have full capacity. We're going to contest and we're going to sue. And they do that by going to court. And basically when the will is filed, they file a caveat saying, hey, this will shouldn't be probated. There were issues here. Mom didn't have full capacity. We deserve our fair share. And then you wind up in court with attorneys making money and fighting over these things. So you always want to, it's always better to do it right up front than having to battle it out in court later.
Indeed. Well, I just want to thank you.
Oh, it's my pleasure.
Yeah, the 5 documents that people need, whether they're 18 or 81. And also the different scenarios. So we're going to be doing another workshop on the 31st that's really going to delve down into each of those 5 documents. So I'll send that information out to people as well, so they can get the detailed information on those. So kind of covered a broad array of things about estate planning. But if you could provide your contact information for everyone. And
of course.
Yeah.
So I'm with Nesevich Law. We have offices in Morristown in New Jersey and Manalapan in New Jersey, Monmouth County and Burlington County. But we serve everybody in the surrounding counties. In fact, I really, especially now with COVID-19 and a lot of stuff just being done over the phone and online, I have clients coming to me from Sussex County. We're really serving the entire state. The website is nesevichlaw.com. Email is a great way to reach me. It's russ@nesevichlaw.com. That comes directly to me. And the phone number for our office is right there on the screen. It's 856-439-6223. And I'm always happy to chat with someone about their situation and see whether or not it makes sense for us to help them.
Indeed. Thank you very, very much.
Thank you for having me.
Yeah, we went a little over, but we had a lot of great questions. So appreciate the questions that people sent in to be responded to, and appreciate you asking them. So our guests are here again as a resource to each of you. So reach out to Russ if you find yourself in need of information about estate planning, and he will gladly provide you with a consult to see if there's a way that he can assist you. If you are watching this live or on the replay, just want to thank you. Remember to like and share, subscribe, share this with other people. It's so very important that people have their documents in order for the event of incapacitation or death. I know those are things that we don't like to think about, but they inevitably can happen. And inevitably, we all got to check out of here at some point or another. So you might as well have your docs in order, because we want to know who's in charge.
Who's in charge? I'm taking that. I'm going to use that in every presentation I do from now on.
Awesome. That is cool. So you can reach out to Russ or myself. I'm at Lyonsview Realty if you're interested in a career in real estate, or if you need assistance with your next real estate purchase. You can catch me on social media. We're here on YouTube, Facebook, and you can email info@lyonsviewrealty.com. So thanks again for watching. Financial Fridays is here to provide you the resources, the information, and the tips on trends that impact your bottom line. And we hope that you receive something of value today. Just want to send love, light, and prayers out to anyone who has lost a loved one, anyone who has a loved one in the hospital for whatever reason. If you're experiencing the impact of physical distancing, if you're getting up, going out the door to work, for our essential employees, our healthcare providers, people in fire, police care, transportation, food, our doctors, and especially our leadership. I just want to encourage everyone to take care of yourself, take care of your family, and definitely stay safe. My name is Clara Lyons-DeVaughn. We stream here Financial Fridays every Friday at 9:30 on Facebook and YouTube. So you can join us again next Friday or watch the replay anytime. Until then, keep living your best life. Thanks, Russ.
Thank you.